Good morning. Captain Retired Matt Edwards here on the 17th of March, 2022 with my observation post weekly report. Going to try to keep it short today. I only made a few notes. I was busy this week writing up a letter that I plan to send soon to Canada Revenue Agency about the stupidity of taxing disabled Canadians. Now, my first point I put into my post on my observation post group is that the rule of law, trusting in government, is vital in democracy. Now, we elect people. We vote. They are supposed to represent us in Parliament here in Canada. Now, in the States, they got a republic, is different, but they are supposed to govern for the people. Now, people might think that everything the government does is for the people, but that isn't always true. Case in point is what I would call a penalty put on people after the Dennis Manoos class action, in which the government put a Treasury bill plus 2% compound daily interest on the taxes that were owed in the year that was owed, and everybody would say, well, what's wrong with that? Well, the problem is that they made a law that was unfair to the people who had to pay the taxes because they had to pay a lot of interest. Now, it was really a penalty, but they called it a tax. Now, if you're going to call it a tax and it's a tax, that's one thing. But if you're going to call a penalty a tax, you're fooling people. So I got a problem with the government fooling people, which is also the main thrust of my point about the long-term disability insurance. Now, Canada has 4 main federal long-term disabilities that I know of. There's the Great West Life policy for the RCMP, covers about 60,000 people in the RCMP, civilians and members. There's about 100,000 covered under the CFSA policy. That's administered by Manulife. Then you had the public service, the unionized people, that's administered by Sun Life. Then you had the non-unionized managers and members of Parliament, that's covered by Industrial Alliance's administration of the Public Service Management Insurance Policy. Now, in all 4 of those cases, the government of Canada, the taxpayer, is the underwriter. Now, an underwriter is the insurer. Basically, they're the one who takes profit or loss, the risk of profit or loss. So they sell it to the Canadian Forces members, the RCMP members, the public servants, but they pretend that it's these 4 insurance companies. That is not going to help with the government when we say to them, like, why are you faking us out with these fake insurance companies? Like, they're real insurance companies, but they're not insuring these policies. Now, what I thought about the other day, I've always talked about several cases that the Canada Revenue Agency took companies that had self-insurance plans, like the federal government, and they took them to task in the Tax Court of Canada first, and then the Federal Court of Appeal. What dawned on me, because I've talked about the Université de Laval Federal Court of Appeal 2002 case and the National Bank of Canada 2003 case, I've talked to them a lot. But what I never thought about was that Canada Revenue Agency basically told these companies, these entities that were employers, stop lying to Canada Revenue Agency that Manulife is the insurer when the employer is the actual insurer. So the government has gone on the record to chastise companies that have faked out the tax system. Now, why does the government get to fake out about who is underwriting these long-term disability policies? Anyway, I want to keep this short. I could wax on about it forever, but, you know, basically, you're going to start off with, in a democracy, the government has to be trustworthy. You don't do something that someone can crap on you later, because then it detracts from our trust in the system. Now, Sun Life Administrative Services only is the second point I made, and I already talked about the fact that Sun Life is one of the 4 federal policies. Now, why I put that note there was to remind myself to look up some of the annual reports that I've read in the past, and I haven't found the year that they said it, But they said in one of the reports in the early 2000s that they were going to formalize the fact that they were administrative services only in reality, but they haven't admitted it yet. Now, that's what goes back to my first point. See, they are operating as self-insurance, which is, according to the Supreme Court in a 1994 case, that's to be commended. If you want to do it cheaper by yourself instead of buying an insurance policy off a company, then you should. But I believe what the Supreme Court of Canada was talking about was when the employer distances itself from the insurance, because if not, you have a conflict of interest. If you self-insure and you don't hire someone to run it independently, then you have the employees in a dispute with their employer, and that's not on. That's not the way it's supposed to work. Anyway, insurance is property, not income. Now, when you have to get a payment, and what I'm talking about specifically here is long-term disability insurance. Life insurance, that goes to a different beneficiary. The person who buys it can't benefit from it. They only can pay it to their beneficiary, their family, or whoever they name it in the policy. But for long-term disability policies, you get the payment if you can't work. Now, the thing is where insurance is property, you don't get paid income. You're not getting money from your service with an employer. You're getting money from a policy of insurance because you paid money and you risked the premium, because you could have gone through your whole career and never become disabled. In that case, you paid your premiums your entire career with whatever company you work for, but you never had to avail of the insurance. Now, that's all insurance buys, is peace of mind. So when someone screws you out of the insurance that you should have gotten, they have breached your peace of mind that you bought a contract to provide. That means that they could be on the hook for punitive damages in addition to the normal damages of the insurance that should have been paid. You might get more money because they get a slap on the wrist, so that it has to be big enough that they won't do it again. It's supposed to be a deterrent from, to the companies and the public at large. But the problem is that they've been getting away with all this shit for so long that everybody thinks it's normal. Now, Interpretation Act, Section 12. I may have discussed this before, but basically what I said before about the government governing responsibly and for the people is enacted in a quasi-constitutional law called the Interpretation Act. Now, for a reminder, anybody who's been watching the stuff I'm talking about, I'm not a lawyer, but I've read a lot. All the laws of Parliament are supposed to form a cohesive code, a whole. All of the laws are supposed to be roughly equal. But the Constitution Act is the supreme law because that gives the authority for the nation. Under that, we have things called quasi-constitutional laws, which are not as important as the Constitution, but not as regular as normal legislation. You have the Privacy Act. That is a quasi-legislation, a quasi-constitutional law. You have the Interpretation Act, because that tells everybody how normal laws have to be interpreted. And then you have the Employment Equity Act and the Canadian Human Rights Act. Laws such as that are more than normal laws. Now, under the category of a normal law would be the Income Tax Act. It is a normal act of Parliament, but I have a letter from 2016 or 2017 where I told CRA, or actually CRA was garnishing my pension. And at the time, I used to be a tax collector once, and I didn't realize that I couldn't be doing that legally because there's a law in place, Public Service Superannuation Act, Section 10(10), that says nobody can touch this pension except in a divorce. Now, Parliament could have put in there, nobody can touch this except in the case of a divorce or income taxes. But they didn't. That means they can't legally touch it. But they do touch it if someone has a tax debt and they don't settle up voluntarily. CRA sends a set-off, it's called, instead of a garnishment order. They send a set-off order to the Public Service, Canadian Forces, RCMP, or whatever Superannuation Act. and then the pension diverts the money physically. Instead of you getting the payment, CRA gets it, and supposedly that's in your benefit to pay off your tax bill. Well, the government has to act within the law. And because there's a law prohibiting what CRA does, then the Public Service, RCMP, and the Canadian Forces Superannuation Acts should, when they get this, throw it in the garbage. They should say, you could have, because you're the lawmaker, you could have put that into the law that you wanted to make an exception for the Income Tax Act, but you didn't. I think that they have to obey the laws they wrote. That's simple. How can we trust people if they don't obey the laws they write? Now, the next one I was putting down is on a related note, and this week will be real short, I think, because I said to myself that law is a social contract. If you don't like Canadian law, you can leave. You leave, then you're not subject to Canadian law, so you can vote with your feet. Now, what I was thinking about was these jerks at CRA, where I was talking to a lady in the appeals office 5 or 6 years ago. And I said to her, that, you're basically taxing us unlawfully, unfairly, because of this, and this. And because this week is going to be fairly short, I'm going to make what I was putting a lot of my time into this week was doing up a draft letter for CRA to tell them, inform them about the problem of taxing people who cannot work. Because the Income Tax Act is designed to tax people who earn a living. Now, if you're disabled and unable to work, you're not able to earn a living, so why, in the name of God, should they tax us? Because that's just not the way it's supposed to work, right? The Income Tax Act was designed to tax income. Insurance is not income, it's property. So they would like to consider the money that we get because you become disabled to be income. But income is what they call an accretion or an increase in wealth. Now, if you're getting an insurance payment, it's because you paid a premium and you risked your money, you risked it, and you gambled with it, and therefore you paid a premium to get the insurance. It's not like you give your time to your employer when you work. Then you get income because you exchanged time for money. In insurance, you exchange money for money. And that's not income. Never has, never will be. Now, what got me on that topic was, I was thinking that public servants work for us, the taxpayers. Now, they may believe they work for, say, Canada Revenue Agency, but basically, because Canada is a common law democracy, they work for the taxpayers. Now, where I was coming from that was I was thinking about the absurd proposition that you hear when you ask the government, why don't you use the same definition of disability at, say, Canada Revenue Agency and Canada Pension Plan? They'll say it's a different act or it's a different department. But they're basically ignoring common sense and tax savings, because if they all use the same definition, then we would have less taxes, because you wouldn't have someone doing the same work twice. So, for example, in the Dennis Manoux class action again, the Canada Pension Plan Disability was one of the proxies that they called it. If you had the Canada Pension Plan Disability, they wouldn't certify, go through the motions, and adjudicate your claim for long-term disability. They would automatically accept that you are going to get it because you're too disabled to work. Which brings me back to my point. If Veterans Affairs Canada, they have a thing called, these days, used to be called Totally and Permanently Incapacitated, TPI. Now they call it Diminished Earnings Capacity, or DEC. Both of those mean that you cannot work. That's what it means. So all of these definitions that relate to ability to work should be joined together. The government should not do multiple work. They shouldn't waste their time and our taxes certifying people who have already been certified. See? So that was where I was coming up with this. You work for us. Why are you wasting our money? Because if they waste the taxes that they collect, then they have to collect more. So they should be conserving the money, not wasting it. That's one of my key themes. Now, that's what I just got into. So next point, I said public servants work for the citizens, not the politicians. Because I will mention one other thing about it, because I think it's part of the problem. Many people, I believe, they think that because the government is doing something, it has to be good. It has to be good. It has to be good public policy. It must not be bad because the government is doing it. That's not always true. For example, Amada Madian, I didn't write these down, something pops into my head. Amada Madian, she was applying for employment insurance. She was getting the income replacement benefit from Veterans Affairs. Employment insurance said, you're getting income from Veterans Affairs in the form of the income replacement benefit, and we're going to reduce your employment insurance. Veterans Affairs Canada, not to be outdone, they said, you're getting employment insurance, which is income, and therefore we're going to reduce the income replacement benefit. Do you see the conflict of interest, the stupidity of this? All they should have done was say, both of these people can't claim each other at her expense. They shouldn't have to have someone like me bring up legal points like, excuse me, but if Veterans Affairs takes into account the employment insurance, they will violate Section 36 of the Employment Insurance Act, which says that nobody can touch it. And if the employment insurance people, they take the Veterans Affairs payment into account, then they are violating Section 89 of the Veteran Wellbeing Act. Laws are supposed to be public knowledge, that once they're published, you can't claim ignorance of the law. The people at the Employment Insurance Office, they can't say, I didn't know about the Veterans Wellbeing Act, Section 89. They are deemed to know it. And the people at Veterans Affairs Canada, the public servants, the unionized members that are getting paid by our tax dollars, they can't say, I didn't know Employment Insurance Act Section 36 forbid me to take it into account. They should know these laws, right? Or Veterans Affairs takes into account workers' compensation. Sergeant retired Bob Grant in Nova Scotia, he has his workers' compensation from an injury after he served in the military, taken into account to reduce the government of Canada's, the taxpayers' expense under the income replacement benefit. But the Nova Scotia law says nobody can touch his compensation for his injury on his civilian employer's time, because that's the exchange they made in a thing called the merit principles. Okay, so in order to get workers' compensation, you had to give up the right to sue. So you gave up the right to sue, which has value, and you are supposed to get workers' compensation for your injury in return. So that payment Bob paid for with his right to sue. But Veterans Affairs Canada considers workers' compensation to be income, and they take it into account to reduce their compensation. Now, there's a principle in the common law. It's called the Bradburn Rule. Now, if you're getting two forms of compensation, then the judge might look at that and say, well, you can't get overcompensated, and therefore this one or that one can take the other one into account. But that would open up a can of worms. Who takes priority? Now, when there's two payments, but one is indemnity or compensation, and one is non-indemnity or not compensating, we don't have that problem, because you're getting one payment to put you back in the place you were before you got hurt, and you're getting the other one because you bought an insurance contract. Now, if you get both at the same time, you're not offending any moral, equitable, legal principles. That's the way it's supposed to work. And, again, I'm doing this off the top of my head, it just so happens that previous Supreme Court of Canada cases said that employment insurance is non-indemnity and contributory. You buy it just like you buy SISIP or other long-term disability insurances. Now, the way that I think this is happening, if someone said to me, how come this is happening, Matt? I think that they believe that you're getting compensated for your injury when you get, or your loss of your job. If you get employment insurance, for example, then they would say you're getting indemnified because you paid the premiums and now you don't have work, so you're getting compensated for your loss of work. Well, employment insurance might not be the best example because you didn't really lose anything. Like if you had your house burned down or you lost your health, then you lost something real. But if you're ready, willing, and able to work and you lost your job, you're still able to work. You just had to find another job. That's not exactly the same. And I'm sure that there are real good reasons why they brought that into the law in the 1930s. But the first time they brought in the Employment Insurance Act in Canada, before Newfoundland, by the way, as a point of trivia, we joined in 49. But in the 30s, when they brought in the Unemployment Insurance Act at the time, it was ruled to be unconstitutional because provinces are the ones that have the jurisdiction over property and civil rights. Now, if they wanted to do it in accordance with our Constitution, the British North America Act at the time, they should have let the provinces do provincial employment insurance. But Canada seems to have a way to make the end justify the means. So they wanted to do an Unemployment Insurance Act. The courts said it was unconstitutional, so they changed the Constitution. I think they did that with the old age security too. And I have it in my mind to look that up to see if I remember it correctly. So if I recall, they brought in an Old Age Security Act. The courts then said, sorry, but this is unconstitutional because pensions are property and civil rights. So again, they changed the Constitution, if I recall correctly. Now, getting back to the Old Age Security, in 2015, for example, there was a bit of kick-up between 2006 and 2015 when people said that, disabled veterans are getting shafted at age 65 because when they turn 65, they lose their long-term disability insurance under the Service Income Support Insurance Plan and or the earnings loss benefit under Veterans Affairs Canada. So this is a problem that the government created because from 1969 to 1995, the Service Income Support Insurance Plan, Policy 901-102, was a lifetime payment. So in 1995, the government was cutting corners trying to save money, so it decided to end the lifetime payment, and they decided to make it like all the other long-term disability across Canada, end at age 65. Now, if you want to be suspicious or paranoid, you might think that they were floating a balloon, a trial balloon, to see if there was enough kick-up about the ending of the lifetime long-term disability, and if there wasn't, they might get rid of the Pension Act. I don't know if that's really the case, but you can make a case for it, because in 2006, they ended the Pension Act, and they brought in the earnings loss benefit for anybody after 2006, and that payment ended at age 65. So, fast forward to 2015. The government claimed it addressed the problem when it brought in the Retirement Income Security Benefit. Now, RISB. So the thing about it is that, like the government does all the time, it decided that it would take into account the old age security to reduce their RISB payment. The problem is the same thing I said about the the Canada pension, the employment insurance. And Amanda, you now have the old age security since 1987, 1988. Brian Mulroney brought in a conditional, you had to have less than a certain amount of money in order to get your old age security. And that was a popular item, I would believe, with the taxpayers, because they would say, why should a millionaire, just because they turn 65, why should they get paid an old age security payment from the government of Canada when they can look after themselves? Now, the problem with ending the universal payment of the old age security is that it is part of our retirement system. So the old age security is supposed to stack with the Canada Pension Plan, and your own savings and pensions. So when they made it income tested back in 87 or 88, they were upsetting the apple cart. That's our retirement system. It's designed to work with the CPP, old age security, and whatever else you have. Now, going back to the RISB problem that I was telling you about, because they decided that they would take into account the old age security, well, they never did their homework, because the Old Age Security Act, Section 42, says that nobody, actually it's Section 36 now that I recall, and the employment insurance is Section 42. So, Old Age Security Act, Section 36, says that nobody can touch your old age security. Now, in a perfect world, in 2015, the Government of Canada, Veterans Affairs Canada, they would not have said, we're going to claw back the value of the old age security. Because there are going to be veterans that have more than $78,000 in payments. And the old age security, they claw back starting at $78,000, and it doesn't end. You don't get a zero payment from old age security until it's about 120-something thousand. So there is a window, say $78,000 to $120,000, that you will get some old age security, but you have a lot of the money yourself from other sources, and old age security would not pay you. Well, if you have a Veterans Affairs Canada payment and a Canadian Forces Superannuation Act pension and a Canada Pension Plan payment, and then they all add up to more than that $78,000, then the old age security would start clawing you back. Now, the problem, like I said, being like Amanda, is that the old age security would claw back to Veterans Affairs, but Veterans Affairs would claw back the old age security. That's not supposed to happen in a reasonable society, because you would think that they would have seen this coming. They're supposed to do what's called due diligence. It's common sense. Okay, if you're bringing in a new law, the law is supposed to fix the after 65 problem for disabled veterans. If you want to claw back the Old Age Security Act, you should read the Old Age Security Act first. Don't you think that's obvious? They wrote both acts. Therefore, to say that they didn't realize it is fucking stupid. Okay? Now, they'll say, of course, that we're not taking the money directly from the old age security. We're merely taking it into account. Now, listen, if you get money deducted from another payment, instead of them taking the money from you directly, it's the same fucking thing. Clawbacks are a form of tax. Did you know that? Okay, the Finance Canada document, the Tax Expenditures Report from 1998 stated as such. I had to figure it out. Now, if you heard me say it before, I'm sorry, I'm repeating myself. But I had to figure it out because they didn't spell it out. But if you have a clawback, and I'll use Amanda Mata Young again. Okay, so Veterans Affairs Canada claws back on the employment insurance. So that means Veterans Affairs Canada saved money for the taxpayers on the expense of the income replacement benefit. Now, employment insurance, they clawed back the employment insurance because she was getting income replacement benefits. So that saved the employment insurance plan money because it took into account the Veterans Affairs payment. But if both do it, she's screwed out of money on both counts because they never did their homework. They never looked at both acts to see that the government, our elected members of parliament, said, no, you cannot do this. And going back to the rule of law principle, what does it tell us when the government writes laws that says you can't do it? And then you do it and you don't get punished? That is not good for society. You're condoning illegal acts. It is much better to err on the side of safety, okay? Instead of saying that you're going to argue an interpretation that we didn't break the law, we merely took it into account. Well, if you're wrong, you might go to jail because you violated a federal act of parliament. And the criminal code comes into play. Section 126 of the criminal code says that if you violate a federal act of parliament that does not have a punishment in it. So if the Employment Insurance Act said that if you break this act, you can get a fine or jail time. Then you can't use the criminal code. So the criminal code, section 126, is a catch-all law meant to make sure that the law can be enforced. See? So everybody knows that if you don't enforce a law, nobody will follow it, because you have to have a penalty or some repercussion if someone's going to thumb their nose at the law. So they get away with it because they're enforcing the law, and they created the law, and then they want us to just vote them in and let them continue doing the same thing. Now, it's getting a bit warmer here in Newfoundland. I'm thinking about starting my protests this time over in front of the Member of Parliament's office, because I have been talking to him and his staff, Seamus O'Regan, since 2015 when he first got elected. That is 7 years of sitting on your ass and not doing anything, and I think it's for political gain. That they know they will lose votes, when all this stuff comes out. They're in power. They don't want bad news coming out until after they leave office. That's what I think is happening. It's pretty low of them. They ought to look at it from the public's perspective and say that, we have to obey the rules. If we don't obey the rules, why should anybody obey the rules? Right? I'm not here spouting off things and trying to get people to get a tax break or to get this when they shouldn't get it. I'm saying, everything I'm saying is based on fact and law. They might try to claim, for example, that, we didn't do anything wrong when we charged all that taxes. We followed the Income Tax Act, section 120.31. Well, I'd like to know how that became a law. How did section 120.31 of the Income Tax Act come into fucking existence so that they decided that they would charge compound daily interest plus at Treasury Bill plus 2% because they lost the time value of the taxes that was owed in the year it was owed? And if they did want to impose that penalty, why didn't they deem it to be the person who never made the payment and not the recipient who had to probably sue to get it? See, the Manouche class, depending on how many people you talk to, which angle you look at it, it was either 4,267 people or over 10 to 14,000 people, because the class size got bigger depending on how you looked at it. Now, the vast majority probably got a small payment, but there were some people who were what was called zero sum, who had such a high pension that they got a zero payment under the Service Income Support Insurance Plan. Now, to remind people, the judge in the Manouche Federal Court 2012 case ruled that that was unlawful. Now, unfortunately, and I hate to make it complicated, the judge was wrong. He was only wrong on the reasoning, not the verdict. Okay? He said that the Pension Act was a non-indemnity payment when it was in fact an indemnity payment. And he said that the Service Income Support Insurance Plan was an indemnity or compensation payment for your lost income when in fact it's a non-indemnity payment because it's paid based on a formula in a contract. That's the reason why you have it being a non-indemnity payment instead of a compensatory payment. If you go to court and you had to sue someone, they would go into your affairs and they would try to figure out what kind of career you would have had. When you have an insurance contract, they don't have to do that. They just pay you whatever's in the contract. You can't convert a payment that's based on a formula into an indemnity or a compensatory payment. It's just not the way it works. For one thing, the compensation principle says that you're entitled to 100%, not 75, not 90% of your losses. So until you get 100% of your losses, they are not allowed to claw back. That is the common law. It's called subrogation. So at the point that you reach 100% of your compensation, you get exactly what you're owed. Anything you recover after you get 100%, that's owed equitably to the person who compensated you, but not until you reach 100%. Now, I wish a lot of people say, well, who are you to say this? I know how to read. I'm not a lawyer. I don't have a degree on the wall, but I know how to read. And these people, they ought to know all of these things that I'm talking about. Anyway, I don't want to be here all day, so here's a point that I thought of the other day, and I was kind of annoyed by the fact that I keep thinking of new things. Back around 2012, Harper decided to increase the contributions for the public pensions. They're not public, but they're Canadian Forces, RCMP, and the Public Service Superannuation Acts. So his reasoning was they're not paying enough. Now, I've often said that people should think of this as a pay cut, because your service ought to be enough to get a pension. Because your employer, the deal is with an employer is that we'll pay you this much now and we'll defer some to the future. That's your pension. So you pay people for your current service now, and you pay them after they have served with a pension. So when the government said that they were going to increase the contributions, that converted the contribution from what is a contribution, which is supposed to be used for a specific purpose, into a general tax. Think about it. They decided that you would pay more money against your will. You didn't negotiate about how much you wanted to pay. They decided that you would pay 50% of your pension, and the vast majority of the public would say, nothing wrong with that. Well, there's something wrong with that, because it's a registered pension plan, which normally has the employer pay 100% of the contributions towards the pension. And the way it works is they have to maintain the solvency of the pension fund, and they have, trying to think of the word now, it's not accountants, actuaries. They have actuaries look at how much money the pension will need to remain afloat. Well, whatever the government has to pay in is based on what the actuaries say, and that's just normal pension law. You can't say all of a sudden that, we're going to have them pay 50%. Well, for one thing, if we don't trust you, how do we know that you're not artificially inflating the amount so that you can say you need more money off of my paycheck? So you want more money, but I'm not going to get a higher pension. I'm going to have to pay more to get it. But I don't get a higher pension. And you're doing it in violation of current common law pension law. Pension law is based on the law of trust. While the owner of the pension is legally your former employer, it is owned beneficially for the pensioner. So they hold the money in trust. So that makes them a fiduciary. And they are supposed to look after your interest ahead of their own. Now, if the government, under Harper, said that we're going to increase the amount that you pay, they are putting their interest ahead of your interest, and therefore they have breached the fiduciary duty that they owed to you. That's a very serious problem. The problem is people think that these payments come out of the Treasury Board and the taxpayer, but they're really owed for past service, so that's with the government as the employer, not the government as a legislator. See? So it isn't being paid to you like out of the taxpayer's money. You earned it with your service. See? So that's the way it is with any pension. If you work for a company like IBM, and the reason I chose IBM was that there was a guy named Waterman, and he sued and went to court, and it got to the Supreme Court of Canada in 2013. And the issue was IBM paid 100% of the contributions into the pension when he was fired unjustly, and he sued and won. IBM argued that they should reduce their payment based on the pension that they paid 100% into. He didn't pay a cent, so their argument was we should be able to reduce our damages. Supreme Court of Canada said, hang on now, you son of a bitches. you paid those payments on his behalf. Anything that he earned in your service, you could have paid him cash, but instead you diverted some of that payment into a pension. Therefore, the payments were made with his property, his earnings. Therefore, the pension is property, not income, which is something I'm always going back to. Because the government would have us believe that the pensions we get are income. Well, no, they're not. In the eyes of the law, they're property because they're savings, because you have a chunk of money that you saved up over your career. And they dole it out. They pay you monthly out of that chunk of capital, property. So the payment resembles income, and it's taxed under the Income Tax Act because you never paid tax on the contribution. You never paid tax while it was vested in a pension. So the government always wants its cut. So it taxes it on withdrawal. But it's not taxed because it's income. It's taxed because they wrote a law that said you didn't pay taxes then and there, so you will pay taxes here. That's the only reason that you pay taxes on a pension. Now, before I go, because I'm tired of talking, I'll mention one other thing or two things that have bugged me. One thing that I've often thought about is that if you become disabled and then you get a reduced, say, Canada Pension Plan, or you get a reduced Canadian Forces or Public Service or RCMP Superannuation Act, it's a bit more of a winger, like I can't say it with certainty like a lot of the other stuff, but Income Tax Act Section 61F5 allows you to take the career contributions that you made into a long-term disability plan and then reduce your taxes, usually in the first year. I think that should apply to a public service, RCMP, or Canadian Forces pension if you become disabled, and the Canada Pension Plan disability. Why should they have two sets of rules that under a long-term disability policy you can claim your career contributions, but under the pensions that you get, you can't claim as a deduction the contributions you made? So I believe that they should treat it exactly the same. Now, this is a fallback position, okay? Because I think these things are supposed to be tax-free anyway. And in the case of the Canada Pension Plan Disability, that was a recommendation by a government report called Listening to Canadians in 2003. So they went around Canada in 2002 or 3, and they talked to everybody that they could talk to, and they got a paid vacation, and then they recommended that the Canada Pension Plan Disability be made tax-free. 19 years ago, and they didn't do it. The law is within their power. They could decide to make it tax-free, and I have a theory that it was tax-free between 1966 and 1988 because they didn't issue a T4AP tax information slip until 1987 or 88. How are you going to tax someone if you don't have an information slip? Right? That's one of the things that I know that they like to tax damages. So if you got hurt in a car accident and then you sued the person who hurt you, I know the government would like to tax you. How would they do it? You're not getting a payment from your employer in relation to the service that you provided the employer for both people's benefit. You're getting a payment from someone who fucked you up, put you in a wheelchair, and they are supposed to make you whole. That is not income. And my practical point is, how would they get to tax it if you don't have a slip to report it? There's no legal requirement to report damages. It's not income. You have a legal requirement to report income, but if you don't get income, you've got no fucking legal requirement to do it. That's the bottom line with a lot of the stuff I'm talking about, is that they legally, or the government, doesn't look at the correct legal classification of a sum of money. They look at it the way they want to look at it. And that reminds me of another thing I forgot to put into my report, but it just occurred to me. I saw an anime that I watch. I like anime, and a lot of it I think is that they're talking in Japanese, and I got to read the subtitles in English, and I got to concentrate on it, so I'm not thinking about all this veteran stuff all the time. But the guy or someone said in one of these anime, you're going to believe what someone tells you if they tell you what you want to believe. So the government wants to tax payments from Veterans Affairs, called the earnings loss benefit or the income replacement benefit. So they decided to tax it as income because they want to see it as income, and therefore they're being told what they want to hear. And they're not going to really look at, is it income? They're assuming it's income. And they changed the name from the earnings loss benefit, which was its original name, to the income replacement benefit, when I say, well, excuse me, but if you think that IRB is such a good name, wasn't that a name available back in 2006, you dumb pricks? So they want us to believe that, just because they named it something else, and the name more closely resembles income, because it's income replacement, that it is income. But the key question to determine if something is income is, did your wealth, did your savings, did your money increase? Oops, used the wrong finger. I didn't mean to give the fuck off finger. I meant to just say go up. If you made a profit, that would be income. But if somebody's compensating you for your injury, and this one happens to be serving other Canadians, risking your life and limb, if you become injured and you're paid an amount to put you back in the place that you were before, that's called capital, not income. And your body is capital. So if somebody gives you, under the Pension Act, a payment each month, the payment is supposed to replace what you lost. If they decide to change the Pension Act into the income replacement benefit and this and that and whatever, the payment you're getting is supposed to put you back in the place that you were before you became injured. See? That can never be income, because it's only supposed to replace, to pay you back for the debt that Canada owes you. You should never have to pay taxes if someone's paying you back something they owe you. I mean, where are these people getting their stupid ideas? Because it goes back, it's all related. They would say, well, it's in the public interest to collect taxes on it, because why should you get a break? Well, if I was getting paid income, I'd agree that I should be paid taxes. But if I'm getting a payment that you call income, but it is really capital, you go fuck yourself. So, if you want to tax it, use the capital taxation rules. But they're using income tax rules on a sum that is legally capital. One of these days, I swear, there's going to be a scandal when people realize what's happening, okay? Because they're basically assuming that everybody wants to save money, okay? So by reducing money with clawbacks, we're saving the taxpayers money. And how is the taxpayer going to be upset if we save them money? We're doing the public a favor. We're saving them on their taxes. But they're false savings, because when they get caught, they're going to have to pay all of the money that they thought they saved in the first place. They're going to lose people's trust. They might have to pay punitive damages in addition to the normal payment that has to put you back in the place that you were before they screwed up. And they might go to jail. Now, admittedly, the risk of going to jail is pretty low. It is greater than 0%, but less than 50%. There's very little chance that they will see a jail time out of this. But there is more than a 0% chance, because technically they are breaking the laws that they wrote. Which, I could go on and on about this, okay? That could be what's called breach of trust by a public officer. When you work for the government, you're supposed to be lily white. You're not supposed to do things that somebody might perceive as unlawful. So when it came time for them to claw back the Canada Pension Plan or the Canadian Forces Pension under the Veterans Wellbeing Act, Regulation Section 22, back in 2006, the Department of Justice should have said, we shouldn't do this because, there's the Canada Pension Plan Act, Section 65(1), the Financial Administration Act, Section 67. They both say we can't do this. And if we argue that we're not really breaking those laws and a judge disagrees, then the Criminal Code, Section 126, could apply, and you could go to jail. So you know something, let's just leave that out and not claw back the Canada Pension Plan or the Canadian Forces Superannuation Act. Now, if a judge looked at it as, you claim these are income, and you're reducing your payment because your rationale is that other income will be used to reduce the payment for, say, the income replacement benefit. Then they say, well, what is the legal character of a pension? Oh, pensions are property. But your premise was that you would reduce the income replacement benefit by income, but the payment is in fact property. They get thrown out of court. They use the reasoning for the clawback, but they base it on false facts. They assume, presume, and say that these payments are income when they are in fact legally property. And people might say, why are you always harping on this, man? Well, there's a big difference between income and property. Income is new money. Property is something you've already acquired. It's that simple. And your body that you're born with is legally property. So your body is not income. Your body is capital. And if somebody hurts your body, they have to repay you in kind. They have to pay you capital to replace capital because you had a capital loss. You can't replace something with something else. You can't replace a capital loss with an income payment. They're not the same legally. Right? Now, again, I wish I didn't know so much because it keeps me rambling on. Okay? Long-term disability payments. They wanted to claw back lawsuit damages. The answer to that for them was to change the nature of an insurance policy payment from a non-indemnity status to an indemnity status. So then they're on the same page and they can claim that they have to reduce your long-term disability because you got into a car accident and then the person you sued paid you damages. Well, now we're comparing indemnity payments with indemnity payments, and we're going to reduce your long-term disability because you got a lawsuit damages payment. I can name 3 or 4 under the government usually. Gibson, Sun Life, 1984, Ontario Superior Court. Sun Life versus Ryan, Nova Scotia Supreme Court, 2003, followed by the Nova Scotia Court of Appeal, Sun Life versus Ryan in 2005. So in the past, these former Canada Revenue Agency, which could be a coincidence, but it's a strange coincidence. How come all these cases that I'm referring to always deal with former Canada Revenue Agency employees and the Sun Life insurance policy, which is the unionized public servants? Why is it that the Canada Revenue Agency employees like myself are sometimes contrary and don't agree with it and then ends up going to court? Or is it because Canada Revenue Agency, seeing that they want to save money for the taxpayers, they want to raise revenue, but tax clawbacks are also a form of tax. Maybe that's why they always end up going to court. So these 3 cases. Then there's the Bruce Bryan case. The Bruce Bryan case had in 2003, he won a Tax Court of Canada case, and they were ordered to remove his T4A forms from national insurance. So without the T4A information slip, there was nothing to tax. 2006, national insurance started issuing T4s again, T4As. So he appealed Now, I always saying Canada Revenue Agency wouldn't be so stupid that, having lost a case in 2003 at the Tax Court of Canada with the person on their own account, in 2006 when the same thing happened, they wouldn't make the man appeal to CRA again. And then certainly if they were that stupid, they wouldn't make him go to tax court again. But of course they did, because they're trying to wear us out. I believe, and many other people believe, they're using the government's taxpayers and resources to drag things out and make us get so frustrated that we'll say, fuck it. But he didn't, and he won for the second time in tax court. Now, having had to go to tax court twice and appeal twice to CRA before he went to tax court, the man sued the government of Canada because that was the underwriter of the policy. It wasn't reported on in the courts as Her Majesty the Queen. It was reported as national insurance. But he got $500,000 in punitive damages as a slap on the wrist so that it would not do this again to people with a similar situation, and $7,000 or $8,000 in taxes. So that is a lot of taxpayer money that would have had to pay this man for punitive damages that they could have avoided by not doing such a stupid fucking job in the first place. Now, it got appealed to the Nova Scotia Court of Appeal, and the damages got reduced from $500,000, which I think was exorbitant too, down to $60,000, but that's still 750% of what taxes were owed. Hey, one more point I just thought of. I wish I didn't have this brain on. I've often focused on this Manouche case and the taxes. But I never, I guess I thought of it, but it never occurred to say it out loud. Not only did they get hit with taxes on their 2013 or so tax returns that they filed after the lawsuit, but on an ongoing basis, they had to pay taxes on the CFSA as well. So the government has had recurring savings each year when people pay taxes on the CFSA program. Now, what occurred to me was I'm going to try to get a couple of veterans that I think will give me their taxes, and I'm going to ask them for their pre-lawsuit victory taxes to get an idea of their marginal tax rate, and then I'm going to compare it to their post-settlement taxes, and I'm going to compare the marginal rate of taxes before and after. And I want to see what the results will be, because I've heard veterans say to me, I ended up losing money after I won. I had to pay so much taxes. And I, being what I think is a reasonable, rational person, would say to the person, listen, but it shouldn't work that way. If you got $100,000 in damages and you had to pay $50,000 in taxes, you're still up $50,000. So you can't really claim that you lost more money than you got. See? So that's my way of thinking when I use reason. But then you look at Tom Anderson, and they charged him $160,000 in taxes on $145,000 in income, and you know something? Maybe they were right. Maybe the veterans who claimed to me that they paid more taxes in than they got in a settlement, maybe they were right. And when you look at every year, they lose additional taxes because they tax the CFSA policy unlawfully. They tax the income replacement benefit unlawfully. They tax it because, as why I say it's unlawful, last point, final point, I promise, and have a good weekend, is that you can't tax a sum of capital in the case of the income replacement benefit. So you'd have a different argument. But if you're getting the income replacement benefit, you're getting compensation under the law. Section 2.1 of the Veterans Wellbeing Act says that the payment is being made as a compensation for injury served in Canada. So they can't claim it's income. It's legally, according to the law they wrote, compensation. Now then somebody's going to say, well, compensation is the same thing as income. Well, no, it's not. If you're getting compensated for your time, that is the same as income. If you're getting compensated for an injury that was done to you, you're getting a capital payment. And I have used a nomenclature system where a capital C for compensation and a small c if you're getting paid for your services. So if you're getting paid income, I use the small c, and if you're paying someone for an injury you created to them, then I use the big C. The same reason for veterans, I use a small v if you retire healthy and you qualify because you fit the definition of a veteran. But if you're disabled in service, I use a capital V in all of my correspondence. And I look at them as different groups of people. Listen, thank you for watching, because, listen to me rant and rave about all this stuff all the time, and I'm always being so negative. People probably think that I hate Canada. I don't. I want my country to do the right thing and not cut corners. I want them to be a country that we can be proud of, that you can look at things and say you're not treating those that become disabled in its service like they're fucking expendable. That you should respect the sacrifice that they made, and you should not try to say, well, you want something special, you son of a bitch. You should say that they gave up something that was very important to them, their health or their life, and therefore we should respect that, and we shouldn't treat them like a piece of shit, because that's what they seem to do. They treat us like a drag on the system. That if you're getting a payment from the government, you're getting this welfare payment, that, if we didn't have as many people getting it, that there'd be cheaper taxes. So, these people, we should try to limit the number of people on it. We should try to limit the number of payments. It has nothing to do with the amount of money you get. It has to do with the recognition and respect and the fact that you need to do things right, by the book, right? And that's partly because I was born with OCPD, Obsessive Compulsive Personality Disorder, which wants things to be black and white, by the rules, by the book. And if you're going to tell me that this is the law you created, then you obey that law you created and you don't fucking break it. That's simple. Anyway, have a good weekend.